Hey, Stephen, how are you?
Good. How are you, Dr. Sean?
Good. Good to see you. It's the day right before the new year, so I figured what better way to celebrate this day than by talking about healthcare fraud, because that is what everyone's thinking about right now. But before we get started, Stephen, can you tell us a little bit about yourself?
Yeah. So happy to be here. And so I am a lawyer who used to be a federal prosecutor. I was a federal prosecutor for 11 years in the U.S. Attorney's Office in Chicago. And most of that time, a lot of the time, did healthcare fraud cases. I ended up being the senior counsel to my office's healthcare fraud unit. And I did lots of cases involving data analytics and lots of cases where I really had to kind of sort through complicated issues as to whether or not these situations were really criminal in nature or whether they should be handled some other way. Because that's one of the big issues that comes up in healthcare fraud cases. I think the government actually gets wrong a lot of the time. And so, and before all that, I was actually a newspaper reporter, which I think really does help inform a lot of what I do, because I really did have a lot of experience actually interviewing people even before I became a lawyer. I left the government about 6 years ago, and I now have a solo practice where I focus on healthcare fraud cases. I've done multiple trials in the past few years, including several which have ended up with acquittals from my clients. And so, yeah, I'm happy to be here talking about this issue. I think healthcare fraud is really misunderstood a lot out there, both by prosecutors and by people in the general public.
And I'm going to take this opportunity to mention the fact that you have a video on healthcare fraud that I'll be sharing in the notes that people can access on the big mistakes that people make in the healthcare fraud world. But before we get started, you talked about this. Is it criminal or is it not? Could you talk a little bit more about that? Because it feels from a non-litigation perspective, anything can be a healthcare fraud issue that has criminal penalties. Is that always true?
So people talk a lot about fraud, waste, and abuse. That's a very common term in the healthcare world. And that's really important because they're very different. So they all involve claims that were submitted that shouldn't have been submitted. There was a problem, there's an error, there's something wrong with the claim. But what makes it fraud as opposed to waste or abuse is really mens rea, a person's state of mind, their intent. And that's really the crucial question as the government tries to sort out these cases. Like, what really is it? Is it fraud or is it something else? Because the big thing that happens, because people make mistakes in medical billing all the time, okay? People misunderstand the anti-kickback statute all the time. People get things wrong a lot. And also, to be honest, there are times when things are very confusing and people believe things are okay, but the government later on says it's not, or some court says it's not. It's not a crime to make mistakes. It's not a crime to be sloppy, actually. What makes it a crime is this key element called willfulness. And that's a very weird term. And it's like the Supreme Court has even acknowledged how confusing that term is. And because it does have multiple meanings. And so, but in the case of healthcare fraud and the anti-kickback statute, what willfulness means is that you knew at the time that what you were doing was unlawful and you did it anyway. That's the key thing. So if you did something wrong, but you totally believed it was okay, even if you were negligent in believing that, you weren't acting willfully. It's not something that should be handled criminally. It should be handled civilly or administratively, not criminally. And that's one of the big things that really distinguishes cases. So when I was a prosecutor, that's one of the big things. Like, okay, we see a problem. We see someone doing something wrong. But what kind of case is it really? And if we don't have strong evidence of willfulness, or we don't think we can get there, then we should handle it civilly or administratively. But that's one of the big things. That's one of the big distinctions here. And there's two real factors to it. So one is legally, because I actually do think there's a lot of confusion out there. And I think a lot of people don't understand what willfully really means. And that's, I think, a real problem just in general. But also factually, I think willfulness is actually really hard to prove. When I was a prosecutor, that was like one of the big things that I really had to sort through. And there were cases where I looked really hard and I didn't have it. And I declined criminal cases that could have gone criminal, but I declined them because we just didn't have proof that someone actually acted willfully. We had lots of proof that someone did wrong, but I didn't have proof that they weren't, to be honest, just an idiot or had been lied to or manipulated. And so I didn't charge those people. And I do think it's more complicated than I think a lot of prosecutors take for granted. And I do think it's something that people really should be looking very hard at in all situations.
So how often is that exact analysis more of a negotiation ploy? This idea that I'm going to put out the criminal charge, but I know fully well I'm not going to get it, so I'm going to let someone plea it down, if you will. And is that something that happens or not quite?
Not quite. So what happens is, okay, so because a lot of this is how things work in practice, okay? So the way it works is a lot of times when the government brings charges, look, I think most prosecutors out there are acting in good faith, okay, when they conduct these investigations. I do think a lot of prosecutors have made mistakes, but I do think they're acting in good faith. And I think a lot of times they'll think based on the information they have at the time of charging that they think they have the evidence they want or need, okay? So I think they have it. They might be wrong, okay? So the tricky thing is, if you're pre-indictment, if you're before charges have been filed, there is much more opportunity to talk to the government, to try to explain what really happened, and to try to get them to reevaluate and not bring charges, okay? So that's why it's always good if you have an opportunity to talk with the government before, while investigation is pending, it's good to do that then, not to wait, okay? The problem is that once charges are actually brought, okay, once the government gets a grand jury to indict someone, it is very hard to get the government to back down and dismiss the charges. Because basically it's public, because they would have to file a motion to dismiss the indictment that will look embarrassing. It's much more public than you would think. And to be perfectly honest, I think there's a lot of prosecutors out there who just won't do it. They would rather go on to trial and lose than to dismiss charges, even if they now realize, oh, you know what, maybe this is not as good a case as I thought it was. That's not the way it should work, but I do think that's what's actually happening. Unfortunately, happens in the real world. So it's not really a negotiation tactic at that point. They just don't want to dismiss. And so that's why, again, it's so important to try talking beforehand, because you can have those discussions like, is this really criminal? Should this be a civil case? You can have them pre-indictment. It's much harder to have them afterwards.
That's really interesting, because I feel like in the recent past, there has been this uptick in enforcement. And I think the DOJ recently pointed out that healthcare fraud is an area of interest for them. But what I find fascinating is it's not just prescribers or even healthcare providers who are the ones being caught up. I've seen recently, in the context of healthcare fraud, you're seeing accountants being pulled up. And I don't know if you've been following that. And I thought that was an absolutely fascinating thing to notice. Go ahead.
Yeah, no, it's actually been a trend for many years.
Right.
If you look back at, so every year or so, the federal government does this big annual, healthcare fraud takedown. And it's something, if you go back, it actually, I think for years, if not from the very beginning, it's been one thing that I noticed was that when you look at healthcare fraud cases, most of the people who get charged are not healthcare professionals. They're not doctors or nurses. They're actually business people. And a lot of them are owners of companies or they're marketers. And I think that reflects some of the changes in how healthcare fraud works. And I do think it actually reflects some of the complexities that the government's trying to deal with. So if you want to step back a little bit, actually, because it ties into kind of something that I've noticed years ago, and something that I think is actually, again, really helpful to understand how healthcare fraud really works. So the way I put it is this. I think people actually don't really have a great understanding of how healthcare fraud really is operating. So I think it's helpful to consider two types of healthcare fraud. Okay, there's the classic healthcare fraud that I think people have a general sense of. So some doctor who is taking advantage of his or her patients, billing their insurance companies or Medicare or Medicaid for things that they didn't actually do, things that weren't as complicated as they think, upcoded, or things that were medically necessary. So that's like classic. Like, and I talk about it. There's this case in Michigan where this oncologist was basically, treating patients for cancer that they didn't actually have. Okay, one of the most egregious cases, in recent times. Okay, all right, that is a huge problem. But actually, if you look at my sense is that dollar-wise, that is not actually the biggest problem. The bigger problem is what I call doctor-enabled fraud. Okay, and that's where you have business people who are basically trying to run a business, but end up getting doctors to sign off on things that the patients don't actually want or need. But the doctor-enabled fraud is complicated because there's a lot of people involved, a lot of different pieces, and there's a lot of people relying on other people to do their job, and there's a lot of misinformation. So in this world, there are definitely people who are actually acting as criminals, but there's a lot of people who are acting in good faith, relying on incomplete or missing information and doing things that help the overall fraud happen, but are not themselves criminal. This is something I saw when I was a prosecutor. And this is something where I could see, okay, I can charge some of the people who are involved, but I can't charge a lot of the people involved because they didn't know enough. And that was actually one of the big things that I dealt with when I was a prosecutor. And that's one of the big things I deal with now that I'm a defense attorney, because I see the government bringing criminal charges against a lot of people who are actually manipulated and lied to. So, for example, the big example you see are doctors. In the doctor-enabled fraud scheme, some of the doctors are criminals, okay? There is this, if you look at this big Operation Brace Yourself, all the stuff with braces and genetic tests and things like that, like there are a few people, doctors, there's a doctor and a nurse out there who basically told everyone that they were reviewing charts and making medical decisions based on the charts, but they were doing so many of them that it was impossible. And really what was happening is they weren't even looking at the charts. They were actually hiring their buddies or their relatives or other non-medical professionals to actually just rubber stamp their signature on all these charts without anyone even looking at them. Okay. All right. That's definitely fraud. Okay. But there were lots of doctors who also ended up doing the same kind of chart reviews, but they were lied to and manipulated by, their employer, by other people. And so they believed, for example, that nurses were actually doing physical exams of these patients, and writing out charts that they were reviewing. There were no nurses, and that was all a scam, right? And so the doctors ended up signing off on lots of charts and orders that were improper. But the doctors didn't know that at the time, and thus I wouldn't have charged those doctors. I would have, maybe something else, right? Maybe some kind of civil or administrative action, but I would not have charged them. Unfortunately, a lot of those doctors have been charged around the country.
So I have multiple questions right now at this second, but I'll ask a couple of them. So the one thing that I have to ask is, in a scenario like that, is there a duty to oversee as the physician, because you are delegating those responsibilities? The fact that you thought that a nurse was doing it, don't you have a responsibility to evaluate if the nurse is doing it and doing it right / doing it well? And the reason I ask that question is I'm seeing in the FDA world, the DOJ and OIG are coming out and saying, we're now going after third-party verification. We want to make sure that in the context of you saying, for example, we have Foreign Corrupt Practices Act compliance, or we have False Claims Act compliance. These people are just sort of signing off a piece of paper saying that they are compliant. but you should have had a responsibility to actually see if they did it. Similarly, in healthcare fraud with physicians, does the physician have an affirmative duty to check on these same nurses?
Well, first of all, I do think it gets really, first, the big answer is they might, but that's not a crime. Okay. That's the big thing. Like, and that's where I go back to you got to look at the right tool. So should have known, should have done better. That's not a crime. Should have known, should have done better. That's more of a civil case. That's more of an administrative case.
Got it.
Criminal cases, you're talking about the loss of liberty. You're talking about prison. Okay. You're talking about much greater penalties and then a much greater loss of liberty. So criminal cases really should be reserved for people who are acting with knowledge that they were doing something unlawful, not people who, they really should have done better. Because because yes, there are lots of people out, and that's something I saw when I was a prosecutor. I would see doctors who were ordering millions of dollars of home health services when they didn't know the definition or the qualifications for home health services. All right. Really, really aggravating. Okay. Really frustrating to deal with, but it's not a crime. It's something that can or should be handled a different way. So you can handle it civilly. You can handle it administratively. You can also the government can also be more proactive and basically identify these problems early on and just cut it off. So one thing that happened when I was a prosecutor, because I was seeing this stuff, I was seeing this all the time. And I was even saying, like, look, there's no way we are ever going to prosecute enough people to stop this problem. Bringing a criminal case takes a ton of resources on the government side. Putting it aside, it's obviously a burden and hard on individual people who get charged. But any criminal case takes up government resources. And I was seeing, like, when we would charge a case in Chicago, and it would not get resolved for like a year or two often. Okay. And it's like, we're never going to catch up. Okay. We're never going to catch up to the criminals if it takes this long to prosecute them. So what we need to do is we need to move faster. And one of the big things that I've been saying for years is the government should do better in terms of data analytics, identify these problems early on, and do direct small interventions to cut people off, educate people to get them out of those fraud schemes. A lot of these doctors who get caught up in these doctor-enabled fraud schemes, they don't want to be part of it. They think it's a legitimate job. If Medicare or someone from the government called them and said, hey, why are you suddenly ordering $1 million of services in this high-risk fraud area for patients you've never seen? I think most doctors would say, would have this wake-up call, and they would quit, and they would provide the government with useful information that they can use to get the real people they should be going after. Instead, the government tries coming years later and tries to say that those doctors were criminals, when they really weren't. Most of them were, I think, just in the dark.
So how useful is the advice of counsel in these situations where you're going, you know what, I want the advice, I got the advice, the counsel is making their best judgment? Number one, is there a responsibility? And we saw that the accountants are being held responsible. You don't see as much of lawyers being held responsible, and I'm very thankful for that. But you don't see lawyers being held responsible, and you don't quite see the doctors sort of being like, are they in a better spot because they did get the advice?
Well, okay. So the advice of counsel defense is something that comes up a lot in these cases, but it actually, and this is something it's a little more subtle. I do think it comes up in two different ways. Okay. So technically, advice of counsel as a legal defense is very limited. Okay. It only comes up if the jury only discusses the idea of, because advice of counsel is what we call an affirmative defense. Okay. So that means the jury really only thinks about it if they actually have already found the person's guilty of the crime. The person's guilty of the crime, but they're effectively excused from it because their lawyer was basically telling them it was totally okay to do it. And so obviously it's a situation where the legal advice was very bad. Okay. So it does come up. Okay. And it does come up. But what actually, I think the subtle thing, and I think at times I got to admit, I'm not sure a lot of lawyers quite understand, is first of all, it comes up as whether or not the government can prove willfulness. Okay. Because advice of counsel defense is very limited. It only comes up in very limited circumstances. And, it's very easy to say, well, yeah, you didn't give enough information to the lawyer. You didn't perfectly follow your lawyer's advice, so the defense doesn't apply. But it comes up a lot in these cases because basically, if you're consulting a lawyer and if you're getting advice back from your lawyer, like it undercuts the government's ability to prove willfulness. Okay, so you don't necessarily have to get to the affirmative defense because you're not really trying to raise that. You're just trying to undercut the government's ability to prove willfulness. So this happened actually in one of the cases I did about 2 years ago, where my client, he did decide to waive privilege. He was a business person who had relied on the advice of multiple lawyers, as well as a biller and some other people. And he was accused of healthcare fraud and violating the anti-kickback statute. And basically he made the decision to waive privilege and basically lay it all out there. And a big part of that was because that was the only way to explain what really happened, because he had been consulting lawyers throughout the entire process. And it was the only way he could explain. But by doing that, he could show that he was acting in good faith the entire time. He was trying to do things right. He was getting some really bad advice, okay? And he got some really bad advice from some of the lawyers he consulted. He fortunately did finally consult a really good lawyer who actually did give him good advice, and he basically finally took it. And it really helped undercut the government's ability to show willfulness and the criminal intent that they need to show. So he ultimately got acquitted by a jury after the end of a trial. And I was even able with the court, and we let us all talk to the jurors afterwards. And it really struck me because one juror just basically told us flat out that one juror flat out told the government that they had no proof of willfulness, which was nice to hear. But another juror had a more subtle point, which is that basically given everything that they heard, everything that we were able to show, like the government regulations were a moving target. It was a moving target. He didn't hit the moving target, but the juror basically said, we're not going to hold someone criminally responsible because they didn't hit a moving target. They tried to do the right thing. They didn't do it, but they tried. That's not a crime. So I do think, so the big thing about that is so first of all, it is good to consult lawyers, okay, if you have questions. Because first of all, you got to do it right. You actually do have to be upfront with your lawyer. You have to tell them what's going on. You have to listen to their advice. But it really does help to show that you're acting in good faith and that you're not acting willfully under the law. So I think it's important. And I do think people facing these situations, I think considering waiving privilege is a very important part of a white collar case. And I think people, you shouldn't just waive it off just because it's difficult. And I do think I've had cases where the government, by waiving privilege, we did have to introduce some things and explain some things that, some emails, some communications that out of context look bad for my client. But it's yeah, but then there's the email a week later, or there's the additional context. But you're also, then the lawyer changed his mind. I mean, so there's things like that. And it all shows that this is much more complicated than the government sometimes thinks. And it really does make it harder for the government to prove willfulness beyond a reasonable doubt, which is what they have to do in a criminal case. Now,
does that advice matter whether it's from a lawyer or a consultant, or is advice advice?
Well, legal advice matters for the advice of counsel defense.
Right.
But willfulness is all about what you believed, right? Did you know at the time that what you're doing was illegal? So, for example, the case I was mentioning, my client had a biller who was telling him that like, this is legal. This is totally okay to do it this way. And even disagreeing at times with lawyers he consulted. That is something that actually creates, again, it is something that goes to willfulness, because it is like, well, I'm hearing different things. I'm not sure who to believe, right? And it does show, again, it makes it harder for the government to prove willfulness, because again, it's not that, like, you know, I've had situations where like, yeah, one lawyer said it was illegal, but other lawyers said it wasn't, or other people said it wasn't. So you can't just cherry pick I've seen situations where I think the government kind of wants to kind of forget about all the other people and just say, oh yeah, this one was, you know, you knew it was illegal because one person told you it was illegal. But it's like, yeah, but then other people were telling you that it wasn't. So it's a little more complicated and it's not as clear cut. And again, the government's burden is to prove things beyond a reasonable doubt. And I think there's a lot of doubt when you're getting conflicting advice from lawyers and non-lawyers.
So what happens in a scenario where you have to have had that thought process of this is affirmatively illegal, I'm still going to continue, that willfulness criteria, if you will. In that scenario, is it better just not get advice? Because no one can ever say you knew something or didn't know something because there's no evidence one way or the other.
Yeah, I mean, yes. If you want to be yes. If you want to be, yes. In some ways, I think the government doesn't quite realize this, but like the fact that someone's consulting a lawyer is actually generally, unless the person's flat out lying to their lawyer and really like a criminal at a multiple dimensional level, right? I mean, like you got to be a really smart criminal to consult a lawyer and still be doing, you know, I mean, it is much more sophisticated and complicated than some of the things. People do it. I mean, people definitely consult lawyers with the idea of covering up and getting
sure.
But I do think actually, you know, proving willfulness is very hard, you know, and so, you know, a lot of times, because it really is about going into the person's head. And so, you know, a lot of times it can be very hard to prove. And so, yeah, so if you, I mean, if you really wanted to be okay, well, look, there's a lot of things that people do that clearly show willfulness, okay? So obviously, if you really wanted to be a criminal, you should not do those things. Okay?
Right.
But for example, you know, I will say it's, you know, that's why, to be honest, like good prosecutors look for signs of willfulness. It sometimes requires subtlety. It sometimes requires things that like some tactics that I developed when I was a prosecutor. And so there are ways to do it, but it can be hard. And so, but like, I don't know, I guess maybe I'll give an example of a counterexample, because there's lots of things people do that clearly show willfulness when they would have been better not to have done it. So when I was a prosecutor, I had multiple cases where healthcare providers would get an audit request, okay? And they decided to or got a request for medical records. And so then basically, because they had been billing fraudulently for services they hadn't actually done or hadn't actually delivered as billed, they created all these fake charts to basically provide in response to the audit requests and the records requests. That made the case a fraud case. I mean, you know, it might have been negligent billing. It might have been sloppiness. But when you create fake patient charts that say you saw a patient on a day when you were actually on vacation in another part of the country, okay, then the government, that is very good proof of willfulness. And so, you know, so one thing that I guess but I will say on that same note, I will say one thing I would advise to any healthcare provider is if you get an audit request or records request, don't do anything that might make the government even think that you're altering records. Okay. So I've seen people there have been instances where I've seen people do like minor things that really were not designed to they're not creating fake charts or anything like that, but like even like filling out oh, we forgot to initial this page of the document. Don't do it. Don't do it. It's just it's better to have, you know, better have a document go in that's mostly complete than to do anything that the government might misconstrue as you altering patient files in response to an audit request. Because
So
that's the kind of thing that really can elevate a case beyond where it should go.
I have two different responses to that. The first one is in the clinical research world, for example. One of the big things that happens is that the physician in the end has final responsibility. They're called the principal investigator. So they have to make sure everything is signed off, everything's like done appropriately, and they're the ones who sign off. And you will routinely have these audits that happen, and they will go in and go, you know what? I want to see these patients. The charts were not signed. These patients, you didn't have delegation logs, whatever. And the response often is, oh, okay, I'll just sign it. I'll just sign it. What I hear you saying is that you can't just sign it. It's not smart. What you want to do is have a contemporaneous record saying, I reviewed this information. We missed this. And here's a quick record saying that I have reviewed it now and it's okay to sign. So keep that timeline still consistent so that no one's ever saying you're altering the record as much as creating a new record. That would be a better way to handle it, or not quite?
Yeah, I mean, I'm not in terms of different contexts. I mean,
yeah.
Look. I think the big thing one has to realize or keep in mind is that prosecutors are people, right?
Right.
And there's a wide variety. Okay, so I have seen if someone realizes, you know what, oh, we didn't dot that I or fill in that blank and fill it in, I know that's no big deal. Okay,
right.
I know that's not criminal intent. And I think most reasonable prosecutors would know that too. The problem is I have dealt with, I know some people, I am very worried about the unreasonable prosecutor. Okay. And so that's the thing. And because a lot of times what happens is, if they've made up their mind about you or, the certain person, it can color their view. So everything you do is like the most negative version. Right. And so I worry about that kind of stuff. And so that's why I think you do want to be careful. And so, look, the best practice is obviously get the records done on time. It's obviously, it doesn't happen at all. It's not, no one's perfect. No one, but the big thing is, one, look, maybe instead of our context that it's okay to go back and fill it in or maybe just make it clear. Hey, you know what, okay, you put your initials, you fill it in, but then you put the little, initials and dates. So it's clear that it was added later. That kind of stuff. It's okay, you're not hiding the fact that you're doing it.
Right.
That's probably a better way of fixing a record.
Right.
Making it very clear that you're adding something later on. I would say though, if you get a subpoena, if you get an audit request, you're in a different category. Okay. That's the thing, because there's a separate crime. Healthcare fraud is a crime. There's a separate crime for obstruction of federal audit. Okay. So that's why once you get a subpoena, you are in a different category. Do not touch anything, period. Okay. Because you don't want to be accused of, well, you obstructed an audit and thus, and thus you did other things. But yeah, no, I mean, I think that, but because it does say a lot. I mean, I had a big case, one of my biggest cases when the prosecutor, involved a healthcare provider that, they were definitely doing improper billing. They got an audit request pretty early on. If they had just kind of turned in the files that they were, acknowledged they had made a mistake, repaid Medicare, stopped billing that way, the case probably never would have gotten to me. But they altered the patient files, they created fake patient files, they kept doing it for years, and the case definitely was a criminal case from that point onwards. And it's one where multiple people end up getting charged and convicted.
I can keep going. I have multiple more questions, but we're past our time. You're an incredible interviewer, so thank you so much. Before we go, how can people reach you?
So my website is stephenleelaw.com, kind of just my name, and I'm on LinkedIn. You can find me there as well. I think there's, happy to help out. I think there is a lot of confusion out there, and I do basically what I do a lot of is I actually, obviously I help people who come to me. I also help a lot of lawyers who come to me too. So because I do have lawyers. Back when I was a prosecutor, people would consult with me on cases, and I'm happy to do that in private practice as well. Yeah, thanks.
Absolutely. Thank you for coming on. And just for those people who are looking and you can't find StephenLeeLaw.com because for some reason you can't spell, check out the QR code at the top. You should be able to scan it and go to Stephen's website. And Stephen, thank you for coming on again.
Yeah, thanks everyone. Happy holidays, Happy New Year.
Happy holidays, Happy New Year.